So, and I'll get to that, and I'm glad you mentioned it, but I just want to close out this one point. So it's bad enough for the department to take a wrongful dismissal with all these political overtones that you've mentioned, and give no reason, or to give a reason that it didn't want to spend any more money, but that it's more harmful to the public's respect for the rule of law if it maintains that wrongfully that the law cannot reach those individuals.
I suppose. I think none of those outcomes is ideal.
Certainly. Let me ask you about the First Amendment defense that seems to be raised in some of the responses from the Department of Justice. In your written testimony, you said that a First Amendment defense would not have lied or been able to be invoked on behalf of the. Can you explain that?
Sure. I have two basic reasons for that conclusion. One is that there's no First Amendment right to intimidate people anywhere at any time. And two, particularly with respect to polling places on election day, the government interests in ensuring easy access to the polls and preventing voter intimidation are so strong that the Supreme Court upheld a statute prohibiting all election-related speech within a 100-foot area of a polling place. So here you have both conduct that is intimidating and the particularly sensitive time and place of the entrance to the polling place on election day. To say that there's a First Amendment right to intimidate voters at that time and place seems to me fanciful.
Well, let me just ask a quick question, Mike. So for these individuals, who wore the paramilitary uniform and engaged in racial slurs, and one of them had a billy club, the original injunction that was drafted included a prohibition that they not appear at the polls, at least these individuals who violated the Voting Rights Act, not appear at the polls wearing the paramilitary uniform. Do you think that that part of the original injunction would have or could have been sustained?
Last question.
Yeah.
I think it could have been sustained because the original injunction spoke of wearing uniforms, but in the course of a deployment. And I think the word deployment sort of captures the idea of going to the polling station and in concert standing guard as if in military display. That seems to me clearly defensible and quite different from an injunction that would have just prohibited nothing more than wearing particular clothes.
Thank you.
Commissioners, do we need another round? Yes. Okay. Vice Chair Thunstrom?
No, I'm taking pass.
I'll pass. Okay. Commissioner Personnel?
Yes. Mr. Katsas, there is ongoing an OPR investigation related to the disposition of this matter. At the outset of the Commission's investigation of this matter, and also that of Congressman Wolf, DOJ responded to inquiries by indicating that there was an ongoing OPR investigation. At the conclusion of such investigation, are you aware of any privileges that would attach to any of the evidence that was considered or adduced during the course of such investigation? And if so, that would preclude the release of any information related to the investigation? And if so, what are those privileges and who has the privileges?
Sorry, the evidence submitted to OPR?
Yes, the evidence and the deliberative process that OPR engages in.
Yeah. I don't think that the mere fact of submission to OPR would itself create a privilege that would extend past the life of the OPR investigation. I do think that much of the evidence likely to have been submitted to OPR would have involved internal deliberations within the department, and that evidence probably would be subject to some form of DOJ's deliberative process privilege. I assume, correct me if I'm wrong, I assume that you all stand on the same footing vis-a-vis the department as Congress. And if that's true, then there would presumably have to be some process of negotiation to work out the competing claims of deliberative process on the one hand, and I agree with what Commissioner Thernstrom said earlier, that those are important, but to balance those deliberative process claims on the one hand with your statutory authority to investigate on the other hand.
Who within DOJ, or is the client the President of the United States, or who would invoke the privilege?
Probably not the President, because there's a distinction in the law between the presidential communications privilege for the President and his immediate advisors, and deliberative process, which is typically the less absolute privilege that governs those of us who served in agencies in lower ranking positions. On the question of who invokes it, I don't know. Probably officially the Attorney General, but my instinct is that the authority to invoke it would be delegable and probably has been delegated.
Aside from the deliberative process privilege, would then any other privilege be the executive privilege?
Deliberative process is a subspecies of executive privilege.
Is there an overarching executive privilege that could be invoked at the conclusion of this outside of the deliberative process privilege?
There is, executive privilege has two components. Deliberative process privilege, which would cover internal deliberations within DOJ, and a presidential communications privilege, which would cover any possible communications about this matter involving either the President or the President's immediate advisors soliciting information on his behalf.
Thank you. No further questions.
Okay, Commissioner Taylor?
I have no further questions.
Commissioner Yaki?
Being round three. Mr. Katsas, would it be fair to say that your knowledge of the Civil Rights Division during your tenure at Justice is pretty thin?
It would be fair to say that my knowledge of the Civil Rights Division was acquired primarily during my year and a half plus in the Associate Attorney General's office, and that the degree of intensiveness of review that one can conduct from the Associate's office about what a litigating division is doing is limited.
So it's pretty thin.
That has a pejorative connotation that I might want to resist. But
The reason I ask,
it's less extensive than, say, an assistant attorney general for the civil division.
but for example,
For the civil rights
you would not know, for example, whether or why the Civil Rights Division decided to turn down potential 11B cases. It would never cross your desk.
It may have, in theory, it could have come up to the associate's office while I was in the associate's office. In
But
fact,
only
it didn't.
But only during that time period.
Yeah,
And what
yeah.
time period was that again?
Let's see, August of 2006 until April of 2008, plus or minus a month.